Your Honour, I appear before you today representing my client Joshua Melling, who has previously pled guilty to the production of cannabis. We do not shy away from the fact that 205 plants were found, nor the paraphernalia which indicate this clearly was a commercial drug growing operation. However, the Crown's position that Mr. Melling is a criminal mastermind and at the top of the criminal hierarchy simply does not stand up. We submit to the court that he was a mere pawn and near the bottom of the hierarchy which the Crown referred to. There is also a significant disparity between the Crown's presentation, the Sentencing Council's guidelines for drug production versus their own guidelines for the sentencing of offenders with mental, developmental and neurological disorders. We rely on the Sentencing Council's guidelines for Mr. Melling playing a lesser role. These guidelines explicitly describe this as involvement through naivety or exploitation and also performing a limited function under direction. This is what Mr. Melling was doing. He was paid in subsistence, a roof over his own head, his own cannabis habit paid for at the risk of eviction and unemployment. He wasn't driving a luxury car, wasn't making thousands of pounds. He was sleeping in a drug production room, watering plants by hand. He was the very definition of a drug gardener, not a drug baron. He's not the Bond villain the Crown would have you believe, merely a henchman about to be thrown into a shark-infested tank by James Bond in the Roger Moore era. As per the guidelines, advantage limited to meeting the offender's own habit prevents this from being a significant role based on any financial gain. I would also like to draw the court's attention to two precedent Court of Appeal cases. The Crown and Zhu, which distinguished gardeners from managers in commercial drug growing operations, and the Crown and Orton, which clarified that the scale of any drug growing operation does not automatically inflate the role of the gardener. So whilst the 205 plants may elevate this to a category 1 harm level, Melling's personal culpability, we submit, remains at the lesser level. The court may ask, well, why did he stay? The answer lies in the diagnosis of autism spectrum disorder, a developmental disorder listed within the Sentencing Council's guidelines, and when pressured by his boss, Mikey, Mr. Melling simply lacked the social resilience and the ability to say no. He was groomed, he was exploited, and his neurodivergent condition made him vulnerable and compliant. In the Crown and Bowen, the court recognises that vulnerability, whilst not a defence, is powerful mitigation for sentence, particularly in this case where Melling was acting under pressure. I turn now to the disposal. As per section 232 of the Sentencing Code, whereas an offender is suffering a mental disorder, the court must obtain and consider a medical report unless they consider it unnecessary. That is, of course, at Your Honour's discretion. However, I respectfully submit that sending Melling to immediate custody would be punishment that is amplified to a far greater magnitude than for a neurotypical man. He suffers from severe claustrophobia and sensory processing issues, and we do not have a medical report, but can we afford to gamble that the noise, confinement, overcrowding and chaos of the prison system would not cause a catastrophic decline in his mental health? The previously referred to guidelines mandate that the court considers whether custody would have a disproportionate impact. In these circumstances, we respectfully submit that it would, potentially even crossing the threshold to becoming inhumane. Furthermore, Mr. Melling is not without societal value. He's a carer. He takes his mother to hospital twice a week, he has a stable partner, and he has a dog for emotional support, a bond that has been shown to be clinically significant for those suffering his autism spectrum disorder. Any immediate custody would sever these ties. He would lose his home, relationship, and support network. Yes, this was a commercial drug growing operation, but Melling was no beneficiary. He was no mastermind. He has no previous history of similar offending. His only prior convictions were drink driving and simple possession of cannabis. He's pleaded guilty at the earliest possible opportunity and is terrified by the prospect of prison. There's realistic prospects of rehabilitation. He has indicated a willingness to accept help to reduce his cannabis dependency. He's got the strong personal mitigation of being a carer and being a pawn, and immediate custody would severely damage his fragile mental state, potentially catastrophically. I would invite the court to consider imposition of a suspended sentence order combined with mental health treatment requirement to address his depression and the conditions that made him vulnerable to this exploitation. And it would be at the discretion of the court to impose curfew to restrict his liberty. I consider these would be viable alternatives to a custodial sentence. Let us allow Mr. Melling to repay his debt to society in the community where he can be supported and rehabilitated, rather than in a cell where he shall be broken.